look at what we have here. So back when I got my first medical card, I had people telling me, "Oh, you can't own a gun now, this and that." Well, maybe they're switching that up. I'm gonna just say this: if you can drink and own firearms, I think you can smoke and own firearms. Let's be real. The U.S. Supreme Court has agreed to hear a pivotal case, U.S. versus Hemeny, which could redefine the legal landscape for flower users who own firearms. The case challenges a long-standing federal law that prohibits individuals who use controlled substances from possessing guns. The federal appeals courts previously ruled that while the government can restrict gun possession for those actively under the influence, a blanket ban of all flower users is unconstitutional. Exactly. This issue is particularly significant in Nevada, where recreational flower is legal and dispos are mandated by state law to scan every customer's ID. Attorney Matt Hoffman from Battle Born Injury Lawyers explained that the federal law originating in 1968 is under scrutiny due to evolving societal norms. Despite flower's legality in Nevada, it remains a Schedule I controlled substance under federal law, which complicates gun ownership for users. Hoffman highlighted that when purchasing a firearm from a licensed dealer, buyers must complete an ATF Form 4473, which includes a question about flower use. Answering yes disqualifies the purchase, while answering no and using flower constitutes a federal felony. The Fifth Circuit Court of Appeals has stated that the ban should only apply to those under the influence while possessing a gun, but other circuits have upheld the broader prohibition, prompting the Supreme Court's involvement to resolve the discrepancy. Nevada's stringent ID scanning requirements for flower purchases create a digital record of buyers' information. Although dispos are not required to share this data with the government, its existence poses a risk if accessed by federal authorities, potentially leading to federal prosecution for illegal gun possession. The law also affects those who already own guns before using flower. Hoffman noted that the federal prohibition extends to possession, not just purchase, meaning longtime gun owners in Nevada who tried a legal flower are technically committing a federal felony. This was exemplified in the Wilson v. Lynch case. The Supreme Court is expected to hear oral arguments in early 2026, with the decision anticipated by June 2026. The outcome could have significant implications, especially for Nevada residents.